1969 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်တုန်းစာမျက်နှာ86 Civil First Appeal before U Josan U and Uthapi Judges McKinsey and others appellants versus Uchipi and others respondents ဤစီရင်တုန်း audio book ကိုထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးမိသားစုကစီစဉ်သည် Code of Civil Procedure suits under Section 92 of the Code for delivery of specific jewelries, whether a personal degree could be passed against the legal representatives, enforcement of the degree against the legal representatives under Section 52 of the Code of Civil Procedure. The plaintiffs, first and second respondents, who had the same father, Upyo, deceased, but different mothers, sued the appellants, who are their nephews and nieces, as the legal representatives of their mother, Domyami, under Section 92 of the Code of Civil Procedure for delivery of specific jewelries which were alleged to be in possession of their mother, Domyami, at the time of her death as properties of the Wakaf. Here, the suit was filed against Domyami as heir and legal representatives of Ubachin, and upon her death, her children were added as her legal representatives, and accordingly, no personal degree could be passed against them. It is true that the office of trustee or manager terminates upon death, but the estate may remain liable for debt incurred during trusteeship. Section 52 of the Code of Civil Procedure relates to the enforcement of the degree passed against legal representatives. Under this section, one of the conditions is that the legal representatives must have received some property of the deceased. Suits cannot be dismissed merely because a legal representative states that no estates are available. All that is necessary is that he is a person whom the assets will devolve. The question whether the legal representative is, in fact, in possession of assets is to be determined in execution. Under Section 52(2), reads with Section 47 of the Code. Ubanyon for the appellant, U Santain for the respondents 1 and 2, U Josan U, judge. This appeal arises out of Civil Regular Suits number 2 of 1963 of the District Court of Maubin, wherein the plaintiffs, first and second respondents, who had the same father, Upyo, deceased, but had different mothers, sued the appellants, who are their nephews and nieces, as legal representatives of their mother, Domyami, under Section 92 of the Code of Civil Procedure for delivery of specific jewelries valued at K 17,000 as per schedule attached to the amended plaint. See also Exhibit Gange, which were alleged to be in possession of their mother, Domyami, at the time of her death as properties of the Wakaf, created by their father, Upyo, and his brother, Upojo, both deceased, and their sister-in-law, Dochanta, BW2, in the year 1926, and for appointment of themselves as managers or matwalis for the administration of the said Wakaf, mounting on the original 8 defendant who did not contest the suit has been added as respondent in this appeal. No written statement was filed by any of the defendants' appellants. The suit was originally filed against Domyami, who, in her written statement, denied that her husband Ubachin, one of the sons of Upyo, died possessed of the jewelry as one of the managers of the Wakaf. She even went to say that she had never seen the jewelries nor the jewel box. She died pending suit. It was alleged by the respondents, plaintiffs, that the Wakaf was created for the public purpose of a charitable and religious nature. The Wakaf, in fact, was not in dispute. After hearing the first respondent, plaintiff, and his two witnesses, the trial court held that Ubachin, the father of the appellant, was in possession of the jewelries while legitimately acting as manager of the Wakaf, and upon his death, his wife Domyami was bound to produce them as his heir and agent. The court also appointed the first and second respondents as managers of the Wakaf and directed the defendants' appellants to return the jewelries or their value 17,000 CHIT to the first and second respondents. The land advocate for the appellant read out portion of evidence to show that Uchipi, the first plaintiff respondent, himself did not see the jewelries with Domyami, and that he only learned that the key to the jewel box was with Upojo's daughters. He submitted that accordingly the appellants were not in a position to hand over the jewelries, but according to the evidence of Dochanta, PW2, aged about 78 years, who was one of the creators of the Wakaf, she herself saw the jewelries, the Wakaf not being in dispute. The plaintiffs who were interested in it could sue under Section 10 of the Specific Relief Act to recover these movable properties, and the questions of limitation does not arise in view of the provision of Section 10 of the Limitation Act. A legal notice, Exhibit Gange, was served on Domyami when she was alive, accusing her of taking possession of the jewelries as wife and legal representative of her husband Ubachin. She was informed of the Wakaf and asked to furnish full particulars of the jewelries which formed the Wakaf properties and for accounts, but she never complies. On the other hand, she denied in toto in her written statement referred to above. There is no denial that Ubachin, before his death, admitted in his evidence in a connected suit being Civil Regular Suit number 6 of 1937 of the District Court of Maubin that the jewel box was in his possession, though he did not have the key. He was admittedly acting as a manager of the Wakaf, and his wife and legal representative Domyami was bound to account for the jewelries, and upon her death, the present appellants as her legal representatives must also account for them. We agree with the land advocate for the respondents that the argument of the land appellant's advocate was based on misconception. The suit was filed against Domyami as heir and legal representative of Ubachin, and upon her death, her children were added as her legal representatives, and accordingly no personal degree could be passed against them. It is true that the office of trustee or manager terminates upon death, but the estate may remain liable for debt incurred during trusteeship. The land appellant's advocate in his reply agreed and submitted that judgment and degree may be ordered to be amended. Section 52 of the Code of Civil Procedure relates to the enforcement of the degree passed against legal representatives. Under this section, one of the conditions is that the legal representatives must have received some property of the deceased. Suit cannot be dismissed merely because a legal representative states that no estates are available. All that is necessary is that he is a person on whom the assets will devolve. The question whether the legal representative is, in fact, in possession of assets is to be determined in execution under Section 52(2). Read with Section 47 of the Code. The amended plain, cause title, and paragraph 15 clearly showed that the appellants were used in their capacity as legal representatives of Domyami, but the judgment does not make this clear. It directs the appellant's defendants to hand over the jewelries which formed the properties of the wakaf, or in the alternative 17,000 jet, being their value to the respondents plaintiffs. It should have added the words Kwelondu Domyami Amweza Amweka Anepien between the words Apsit Habi and Diakamyadi in the second paragraph under issue number 11 at page 14 of the judgment and also in the body of the degree. In the cause title of the degree also no mention is made as to their status that they are legal representatives of Domyami. In the result, the judgment and degree of the lower court as ordered above to be corrected are confirmed. The parties shall bear their own cause in this appeal.